My name is Clare Daly and I am a member of the European Parliament. I believe that the prosecution of Julian Assange is a grave threat to the freedom of expression in Europe. I'm the rapporteur for the annual Fundamental Rights Report for 2018-2019. I believe that no report on the situation of fundamental rights in the European Union could possibly be taken seriously if it fails to mention the Trump administration's radical and dangerous prosecution of a journalist for important journalism that was carried out in the European Union. That's why, when I was drafting this report, I made sure to include a statement about the Assange case. However, on Monday at committee, when we were finalising the text, the European People's Party, the Socialists and Democrats and the Renew Party voted to remove all reference to Julian Assange from that report. The text of the Fundamental Rights Report is now deafeningly silent on the most important press freedom case of our generation. Well, we're not going to take this lying down. On Tuesday next, the vote will go before the whole European Parliament. I'm tabling a plenary amendment to put back the reference to Julian Assange. We need your help. We need you to write to your MEPs, tell them why this case is so important for press freedom in Europe. Urge them to vote for our amendment to add Assange back into the text and make sure they know that you'll be watching them on Tuesday. Help us to make sure that the European Parliament recognises and acts on the serious threat posed to fundamental rights of all Europeans by the vindictive and illiberal prosecution of Julian Assange by the United States government. Thank you.
I was the first person charged for giving information to the American public under the same statutes and charges as Julian Assange. We do not have an Official Secrets Act in this country, as in the mother country, Britain, because we have a First Amendment, a freedom of the press, freedom of thought, freedom of association, which has always, before my case in 1971, been held to preclude either a prosecution like mine under any statute, or specifically an Official Secrets Act, which would criminalize any release of information that the government wanted to keep secret from the public. And in this case, then they tried the Espionage Act, which was meant for spies who give information secretly to another country, especially in time of war, had been used very much for that. And to use that on someone who gave information to the American public, me, for the first time. Since then, really 10 years went by before there was another prosecution. Mine was dismissed for reasons of governmental misconduct against me during the trial, criminal conduct, which led actually to the resignation of Nixon in the end, and to the prosecution, the conviction of a number of his subordinates who had been involved in that. It was another 10 years before there was another case, and then about 10 years after that, a third. Only 3 before President Obama. One went to the Supreme Court and they refused jurisdiction. So the Supreme Court has never, to this day, addressed the question of whether it can be constitutional to prosecute someone for telling the truth to the American public. They haven't ever addressed that. There's a very strong constitutional case against that. Whether the majority on this court would notice that or not, nevertheless, it hasn't been tested. President Obama brought 9 such cases, 3 times more than the 3 that had been tried before. But even he did not apply it to someone unlike me, who was an official who had had a security clearance. All the other cases involved those, and try to apply it to a journalist, as the wording of the Espionage Act permits. It's extremely broad. Under earlier constitutional doctrines, that Espionage Act would almost surely be thrown out on grounds of overbreadth, because it actually applies in the wording to anyone giving, it doesn't use the word classified, but information relating to the national defense that's being protected to an unauthorized person, or reading it, or possessing it, or keeping it. Any of that. In other words, would apply, the wording, literal wording, would apply even to readers of a newspaper who were warned that this is a leak of classified information. And if they give it to their spouse or whoever, and they protect it, they don't give it back to an authorized authority, as the wording of the law requires, they could be subject to this too. Well, nobody had ever tried applying the law that far. It would so clearly lead to, if it got to the Supreme Court, to a judgment of unconstitutionality, and then we wouldn't have any threat to hold over people at all in terms of legal prosecution. Obama considered using this against Assange, actually, in 2010 and 11. And remember, he gets out in 2017, early 2017. In all those years, he did not apply it to Assange because of the reasons I've given, and for the practical reason that he could not explain using that against Assange and not against the New York Times, or for that matter, the London Guardian or Observer who used this. Assange, after all, who's not an American citizen, is being faced with extradition by the British to another country for having allegedly violated its laws on security. Now, a lot of countries have laws even a lot tougher than ours on security. Imagine how this could be applied elsewhere. So, yeah, in this case, he backed off from charging Assange rather than charge the New York Times as well, who had published the same material. The ACLU warned at the beginning of this administration that this president was very likely to extend the law further to apply to journalists and publishers for the first time. And that is what we see with Assange. And the very fact, Jimmy, that you mentioned earlier, that some journalists have chosen to remain aloof from this on the grounds that he's not really a journalist, as Bill Keller put it, of the New York Times, not a journalist as he could see it. Fact is, if he is extradited and prosecuted here, in the current climate, I would say he would almost surely be convicted. We couldn't count on the Supreme Court to recognize that this was a clear violation of the First Amendment, and we wouldn't have a First Amendment applying to governmental secrecy, to national security at all. We'd have nothing but handouts from then on, and we would have more wars based on lies like Iraq and the others. So Vietnam, in my case, Pentagon Papers. So a great deal hangs on this. And finally, Jimmy, if I may address your question you asked, I think, Noam, why is the press staying aloof from this? To my belief, the press has been in a state of denial since my case, and that was 1971, that was 49 years ago. And I have been saying, I can tell you throughout that time to audiences of journalists, some cases publishers, AP editors and whatnot, this is a buried bomb, a mine, in effect, waiting for you. If you do not examine, investigate the secrecy system and the abuse of it, and the wrongness of the use of this law against this, it is going to be used directly against you, as well as to your sources. They were surprisingly acquiescent at the notion of it's being used against sources, actually. The legal aspects of that, in my case, were hardly ever examined, or in the other cases which have been going on under Obama. The very frail, well, the unconstitutionality of really what's being done. And so they've stayed aloof from it. Oh, this will never touch us. We have an arrangement with the government. We do our best to find secrets, and they do their best to keep them, and it works out pretty well for democracy. Well, it hasn't worked out well for democracy or for our victims in Iraq and Afghanistan, Somalia, Sudan, all these other places that are victimized in secret wars, and it hasn't worked out well for our democracy at all. So the Assange case gives journalists a chance now to focus their attention at last on the direct threat to their freedom of speech and the unauthorized disclosure, which is the life's blood of a republic.